is Henry Quillian. I'm here at Taylor English with my colleagues. We are doing this particular Litigation Fundamentals with Henry Quillian virtually for recording and for your benefit. The topic today is avoiding this down the road issues associated with electronically stored information and also unscrambling electronically stored information in the event that there has not been adequate and sufficient ordering of the information during the course of projects. One of the particular focuses would be situations where there are multiple professionals or people working on multiple projects over a long period of time, and then where one particular project goes into a dispute, and there are similarities between among all the projects all these people have been working on for a long time. And so you have the situation where an opposing party on a particular matter requests electronically stored information. How do you unscramble it if there has not been discipline employed throughout the course of time where the documents that are specifically associated with the matter in dispute can easily be identified? So we're going to start with the situation of or the recommendations regarding disciplines that can be employed and things that you can recommend if you're a lawyer or especially a general counsel, recommend to your clients to try to avoid the nightmare that results at the end of the day if you get into a litigation and there is no discipline that has been employed over time. And also talk about how do we deal with elimination of privileged information, dealing with confidentiality obligations to other clients and customers of the company besides the one that you have a dispute with, and what can you do to anticipate these problems and hopefully avoid immense expense at the end of the day associated with unscrambling ESI or electronically stored information should you get into litigation. So as mentioned, the basic problem is, and this has happened numerous times over recent years to my clients, so that's why I'm particularly attuned to it, is you have maybe 5 or 6 people who work on a lot of different projects, and it could be construction projects, could be software projects, could be a lawyer exercising their roles in their role as a lawyer, but all of which have similarities such as construction of a building or dealing with engineering topics or software terms, so that search terms do not in any way reliably both pick up the documents out of electronic discovery that are needed for the dispute and also eliminate the unrelated emails for other projects. And if this has been going on for a very long period of time, you have the circumstance where you can end up with reams and reams and reams of information, all of which has to be processed from the get-go at very large expense before you can even run electronic search mechanisms in order to get rid of all the unrelated information. And then, of course, you have privilege concerns and confidentiality concerns as well. So, and I had one matter that concluded in 2020 where the proposed cost by the ESI provider, which is an outside vendor, to simply run the data through their system to get it in the form where it could be searched using Boolean technologies and other technologies was $160,000. That was just to run the information after it had already been collected. So that can give you an idea of how expensive it could be, because collection, in other words, getting the emails, let's say, from 10 different people is expensive enough. But if you then have to pay $160,000 just to convert the information into usable form, uh, that is devastating. And then to get the information that the other side actually is entitled to have could be another $1 million+ if you have that much data. So let's talk about things that could be done by a company. Granted, it would take discipline by the employees of the company and some sort of enforcement mechanism by the company in the event that discipline is not imposed, but it also could save tremendous nightmares down the road. And it also, frankly, because communications are the principal problem that ESI is addresses, such as emails, memoranda, and other documents, it also can actually facilitate better communications within the company. So there's a positive side to it. Okay. So what do we do? So we start off with time zero, and presuming that, let's say, somebody is hired on and this person is going to be a material participant in 10 different projects. And these projects are all of similar subject matter. Let's say it's building churches all over the Southeast. And so you're going to have the word church in every every email or something, and then obviously normal terms like roof, foundation, wood, supplies, subcontractor, etc. So that you're going to end up with a whole lot of emails that look to the same to the outside world, but are in fact about completely different projects. And this person knows they're going to be dealing with all these different projects. And they come into the scenario where we want to be able to know down the road which emails are associated with which project. And then from that set of emails, select the ones that are relevant to the dispute at hand. It might only be one dispute associated with a 4-year project, but it might have run the entire time frame of the 4-year project. So how can we set up things so it's more likely that we can reduce some of the sorting at the end of the day? Well, it has been observed by me and also my colleagues that it's very helpful, and I do this in my litigation, to have in the subject line some sort of unique identifier that's required to be in the subject line when communicating about a particular, in my case, lawsuit, in a business person's case, a particular project. Now, what people are resistant to do is to have to type out a tremendous amount of long codes, such as a 8-digit project number, because they can't remember all the project numbers and they're all generic and don't really make sense. So it's possible that, for instance, if you have a company that's been around for a long time and the project numbers are very long, that perhaps only the last 4 digits would be a unique identifier for a particular project. If they're not doing more than 1,000 projects a year, or over a reasonable period of time of 5 years or whatever. Also, to facilitate communication, if you put that unique identifier, and it could be a word such as the location of the project or the street number in which the project exists, something that is agreed upon by all parties at the very beginning of the project, that is going to appear in each and every communication and is somehow unique to that project. It is also, of course, very helpful to communication if people put in a subject matter on the subject line that actually relates to the subject matter of the communication. In the olden days, when we wrote letters, everything would have an RE, and you would write relatively few letters compared to emails. and you would have a just identification of what the subject was of the letter. Uh, Furthermore, if you have a privilege associated with the email, whether it be attorney-client privilege or if there's already a dispute brewing, a work product privilege or materials prepared in anticipation of litigation, the parties should agree upon what they're going to put in every single communication regarding that subject matter, so that using I will say top line level search techniques such as in Outlook or that those emails could be immediately extracted from the group of maybe tens of thousands of emails that the same person has communicated with on the other 9 projects that they've been working on over the multi-year period. And I note that though I don't know the exact technique, I'm pretty darn sure that there are macros that could be used to put in the unique identifier for a project, which is usually like a control F or something like that, or control P, to put into the, just to insert into each email relating to that project, the unique identifier. And of course that might not work on a phone, but basically people just need to take the time rather than just whipping off an email to put in the unique identifier, which will also help the communication within the company. Now, the benefit of that, of course, is if after 5 years there's a blow up on the project, those terms can be used to find, with a reasonable degree of reliability, at least the first major set of documents to produce or to look at if you're the actual party that wants to look at their own documents, for figuring out what the dispute is about and who is involved, and to get to the communications back and forth on that project. Now, sort of a second level of work by employees that's less likely to be employed, as I've observed, in part because a little bit harder to do on cell phones, is to utilize a foldering technique. Now, that's what a lot of us use, just dragging emails into a folder that's specifically relating to a specific project or client or sub-project for a client, so that and that's sort of the dream world, to say, okay, I'm pretty sure that 98% of my emails relating to this project I dragged into this folder on a daily basis or an hourly basis, and that set is separate and apart from all my other projects, and I've got this ready to go to look at if anybody ever asks me about this subject matter. And of course, you can have subfolders. Now, trying to actually get that done by employees of the company could be really difficult, but maybe there's some sort of motivational technique that can be utilized within a company, such as bonusing or something, that where there's an audit of people's emails to see how well they did, and they get extra money if they do it well. They get dinged if they don't, and so dinged as far as compensation goes if they don't. There also may be, if you do use that macro or unique identifiable term, there are probably rules that can be set up within Outlook or other email management programs that will actually automatically drag stuff to the right folder. And then additionally, if you're working with third parties, such as, let's say you're a company and you're working with a lawyer, try to get the lawyer to participate in the same program. Or if you're an owner and you're designing a building, try to get the architect and the engineer to utilize the same unique identifiers, maybe even put it in your engagement agreement, that is a requirement of you working with those people, so that their communications with you don't get sloppy, and at the end of the day, you'll have the set of data that you need readily accessible, rather than just having a huge mishmash of 25,000 emails that are all messed up together. Another thing that that I've observed over time, and if anybody has any questions, certainly just raise your hand. I am keeping a look at the list. Is that even those companies that utilize the most disciplined techniques on a day-to-day basis often do what I'll refer to as boneheaded activities that mess everything up along the way. An example of a boneheaded activity would be separate, because of some corporate transaction or some IT person's decision. One would be turn off the web storage for a critical employee so that all the data just disappears. And that has happened before. It's a nightmare for the attorney in litigation when they find out that the client has just, in the middle of the dispute, because of trying to save $5 a month, has turned off all the email for on the web or stored in the cloud somewhere for one of the critical witnesses. Another one would be archiving, where they archive the information and forget where they put it, or they mix it all up after it's already been separated in some sort of archive. Another one would be a purchase or sale of a business, or a merger between two businesses where they don't care. It's not an important business term, and so they either lose the data or don't separate it out, or lose all the organizational techniques that have already taken place because they all of a sudden got new software or a new system, and they figure they'll just dump all the data over here in a pot, and because they're not anticipating a problem or a dispute, and then a dispute comes along, and they have a big amorphous mess, if they have it at all, of the old data of the previous company or the purchased company. The other one is termination of employment, and I'm sure the employment lawyers would have a lot to say about this. They either let the person take their laptop, where unbeknownst to the company, that's where all the emails have been stored, or people use personal emails, and then they no longer want to let the company access their personal email addresses, or they use both company and personal emails, so nobody knows how many different email addresses the relevant information is to be found for a particular person. Or they do things like I mentioned, turning off the cloud storage for the person as soon as they leave the company, and then you're stuck with either trying to go get it back, if it's some sort of POP server or something, trying to get it off the laptop of the ex-employee, or something of that nature. So basically, those types of things can really result in huge expense, nightmares, lack of evidence that's presumed to be present, that can also run up a lot of legal fees associated with ESI. So that side of the discussion is principally loss avoidance and communication improvement side of thing, and we've seen all of these in very recent history. One of which we ended up going through maybe 5 hearings with a 3-person arbitration panel trying to sort out orders over disputes about how data would be extracted from a huge set of information. I happen to be utilizing my library background, and picture this. Picture that 1 out of every 10 books, but nobody knows which one, contains a page with critical information regarding a project and dispute, and all the other books that are in the library behind me don't have anything to do with the dispute at hand, except for that single page in 1 out of every 10 books. And how are you going to, and all the other books are the active books of the person involved. So how are you going to find those pages out of those books? it's easy to talk about, it's very hard to do. Do I have any hands or anybody wants to share some sort of technique or bonus system or penalty system or anything else that's been utilized by them or their clients that they know of to actually get employees and officers to utilize discipline in their ESI? If I don't see any hands go up, I'll just continue on, but let me just scroll up and down, make sure I'm not missing anybody. Okay, I'm not seeing any. Certainly chime in though, and I'll just keep an eye out for hands. But if you know of a system that works, because it's probably one of the harder ones to implement because it slows people down, but that's what best practices are oftentimes, is slowing people down to make them think about the long-term effects are of what they're doing and how to avoid bad long-term effects. Okay, so let's assume that none of these techniques have been utilized by a company, and they've got, let's just use a modest sized company, they've got 10 people who over a period of 10 years have worked on 20 projects each, all with the same general subject matter. And the reason why the same general subject matter can be very deleterious is the search terms that would be normally provided by an opposing party in order to seek the information that they want relating to the lawsuit may be the same exact generic sort of terms that are used every single day on every single project by all of those 10 people over the 10-year period if they were all working on the project for 10 years. So the search terms essentially would produce a gazillion communications or documents that don't have anything to do with the project that's in dispute, but they are exact hits for all those non-dispute projects. And so they essentially, the search terms do no good as far as getting rid of the communications that are associated with the other projects. And then you might have one nuclear power plant, one government military contract, a company that is doing some sort of internal investigation or something, all of which have very sensitive information associated with them, so that producing information not associated with the project that's in dispute could be very detrimental to the company and potentially the clients of the company, and breach contracts and breach statutes, etc., all which can lead to a huge problem. So upon learning of a dispute, think of about the basic things that need to be done. Litigation holds need to be distributed within the company, which would mean identifying the custodians that likely have information about a particular dispute, identify the scope of the dispute, tell them to stop any sort of document destruction program, don't delete anything personally themselves, and otherwise don't lose your data by doing something bad. If you're prone to drop your iPhone in the toilet, go ahead and back up all the hardware to avoid inadvertent elimination of data. Also, when a dispute is in place, once it's identified as something that's likely to go to litigation or otherwise arbitration, start implementing work product protection disciplines such as labeling documents. If it's appropriate for an attorney to be involved on a particular matter, start copying the attorney and marking things attorney-client privileged. Send out hold letters to opposing parties and critical witnesses on your side to ask them to hold on to all their information, not to lose it, not to let it get lost in the termination of an employee, for instance. and basically make sure the data is secure. Uh, and then also, uh, you've got to start figuring out, okay, when were various people involved with this particular project? Because unless you just have a super stable organization, chances are people will have come in and out of the project during the time of their employment. People will come into employment and leave employment, and then might actually get reemployed by the same company again. And those time frames are going to be very helpful in figuring out which data you never have to look at. For instance, if somebody was working at a company on a project, left the company for 2 years, and then came back 2 years later, anything that was copied to that person during the time they were no longer at the company would not be relevant, because that person never would have gotten the email. And then secondly, you can just look at the time frames where the person was actively involved with the project. Okay. So as we're talking about this, our big concern is unscrambling the huge mess of eggs that have been put into the frying pan, for lack of a better description, where you just have an inbox with thousands upon thousands of emails, but no subject lines, no unique identifiers, email strings that go back and forth on various subjects, where people have not decided to start a new string to cover the new subject. They just keep hitting reply all and never change the subject line. Problems like that. So how do you get rid of the non-project and dispute related emails and documents? Well, you can, if it's a professional services company, you could think about, one, listing all the people that were involved with the project who also have been identified as custodians where the other side wants the information. Two, go into billing records and figure out when those people were actually active on the project involved. Most professionals who bill by the hour will actually put in their time, real time or close to it, associated with the project. And so you can say, okay, this person was off the project for 6 months and then back on later. And then for each custodian, you would start developing a list of knockout terms, which usually a but not search term would be used in a search tool to try to get rid of all the documents that would be applicable for that but not term. And so what you would have to do is, for each custodian and for each project, try to identify terms that would never be involved with the project that's in dispute. So if you're a general contractor, a good name would likely be the other owner of another project that didn't have anything to do with the project that's in dispute. Perhaps it would be the subcontractors that never were involved with the project in dispute. Perhaps it would be individual people who never touched even within your own organization, who never touched the project in dispute. So you start developing a list of terms that are going to get rid of as many non-project related communications as possible. And you do that for each custodian after figuring out the time frame that each custodian was involved. And then you would run those but not terms at the highest level your systems are capable of doing to try to eliminate as much data as possible. This is not a selection not the needle, pulling the needle out of the haystack. Is basically trying to get rid of the haystack type undertaking. And as much of the haystack as you can get it down to a small stack instead of a huge mountain, then you can cut down on your processing costs and everything else. And of course, you're going to have to do most of this by stipulation and agreement with the other side, because this is a lot different from just looking at everything and producing responsive documents. It's really trying to get rid of as much as possible and then looking for responsive documents. So once you run the time frames and the but not, hopefully you'll end up with a small stack of documents. Let's say rather than 25,000 emails, you'll end up with 1,000 that had not been eliminated by the but not terms. And then, of course, you would have to do what you traditionally do, such as running privilege terms. If it's attorney-client privilege, you would run the emails addresses of the attorneys involved to get rid of, at least set aside for the time being, the privilege documents. And then same thing with respect to materials prepared in anticipation of litigation. If you can identify a time frame in which litigation was anticipated, so you could put those aside to take a special look at them to see if they were actually describing the claims and the calculation of damages or evaluation of liability, etc. And along with the other side and perhaps the court or arbitrators, you would enter into a confidentiality agreement so that if documents that are inadvertently produced relate to other projects that have nothing to do with the dispute at hand, or if privileged documents are accidentally produced, first of all, they would be confidential and be held by a limited group of people in the other side. And then also you would have certain, what they call clawback rights, to say, okay, I've learned after the fact that I gave you these documents relating to the nuclear power plant, which also had a pipe of the same name as the pipe involved in the hotel. We need to get back all the documents relating to the nuclear power plant, because that power plant's not in dispute and you don't have any right to know about the pipes inside the nuclear power plant. So that's one mechanism that we've utilized in recent history, and you're never going to get everything if you use these but not terms. Somehow or another, there's going to be a but not term that eliminates some documents that you might actually want to see. But depending on the circumstances and a little bit of luck, you won't get rid of the documents that are the ones that you desperately need to prove the case. And hopefully, or you can get the same information by cross-examination or admission from the other side. I don't see any hands. Anybody want to discuss this particular mechanism for trying to get rid of documents? I will tell you, we've tried this sometimes with success and sometimes not. Oftentimes we'll find a critical custodian has what you think is a good but not term in every email they have. And you find out it's in the email legend or underneath their signature or something, where you think you're going to get rid of only documents that relate to some other project, and then you find out you're wrong, that in fact you're getting rid of a lot of the documents that associated with the project in dispute. And of course the other side's never going to want to agree to that. So you do have to run, you have to see what happens once you run the search terms and see if you get an anomaly where all of a sudden the person that was in charge of everything has very few responsive documents. Something's going to be wrong there. The other thing we found is that people sometimes, if they're in the same organization, they talk about 3 different projects in the same email, which goes back to that discipline I was talking about earlier, is trying to keep communications on one subject matter rather than trying to cover the entire waterfront of all the discussions between the people at the company, involving every project in a single communication. Okay. How else can you get rid of excessive emails? And this has been utilized effectively, and it also does involve negotiation with the other parties to the dispute, and that is utilizing what's known as technology assisted review. And essentially, this is an artificial intelligence technique that has been come about in the last 10 years or so, and it has been improved over time, that you utilize computers to help decide which documents are most likely associated with the project at issue or the issues at hand. And also, hopefully, most likely eliminate a lot of the emails and other communications that aren't at all involved with this particular project, or which uh, aren't on the subject matter of the dispute. Generally, the way this is done is the lawyers involved, this is an after the dispute has arisen situation, the lawyers involved set up a set of issues that are going to be associated with the dispute, and also the individual subject matters of those disputes. Not so it's not just legal issues; it's subject matters associated with the disputes. And then you have trained reviewers review the documents, usually of the most centrally affiliated person. Let's say it's the project manager for a big construction project, who's supposed to have most everything important run by him or her. So you get the most data rich documents, most issue rich documents of the person, from a person who's most likely to have a touch on every subject matter. And you would tag those documents for responsiveness and also for various issues that are covered within the document, by way of having an actual smart person look at the documents, figure out what they're associated with, and marking them as being responsive on not only in general to the project at hand, but also more specifically to the subject matters that are involved in the dispute. Of course, a whole lot of times, you might have 99 things that went right and one thing that went wrong, and that one thing that went wrong is what everybody's fighting over. So if you can get rid of all the 99 things that went right, you can also reduce the amount of data substantially. And then that's those set of documents. Let's just say it's 1,000 emails where they've been marked by professional reviewers who are trained. For lack of a better description, it will be fed into the computer, and the computer will, using it's often proprietary software of the ESI provider, will come up with a profile, for lack of a better description, of documents that are likely relevant. And that could be also associated with the people that are involved on the communications. And that profile will then be utilized to you run it across the set of all the data, and this is intended to percolate to the top for review by people, the documents that are most likely going to be associated with the subject matters of the dispute within the project that is in dispute. Those people will then start reviewing those emails and communications and marking them for the subject matters, and also for responsiveness, and also whether they're associated with the project at hand or not. And each time they mark a document, it actually trains the computer more regarding what the computer needs to be looking for, and the computer will then propose the next document using an algorithm, which percolates those documents to the top. And eventually, the idea here is that the computer will, on its own, try to say this huge set of documents that's at the bottom of the stack after each running this algorithm over and over again have a very, very low probability of being associated with this project or the disputes at issue. And of course, we're looking to do a lot of things here. You're looking to eliminate the number of documents that need to be looked at. And also you're trying to eliminate the amount of time associated with people looking at documents. And you're also looking at trying to get a much smaller set of information that anybody has to deal with in this litigation. Because, if you end up with 100 million critical documents for a litigation, brains can only handle so much, courts can only handle so much. So you got to get to the really important stuff. And what we found is you then have to have somebody who's statistically oriented and who knows this program and can provide historical information regarding the success of the algorithms in choosing the right documents needs to be overseeing this whole process, because the goal is that at the end of the day, this ESI provider expert will be able to provide a statistical analysis showing to the opposing sides that it's no longer viable or reasonable for anybody to want to look at the huge stack of discarded documents, which are left after the algorithm has run. So eventually the parties, possibly in advance, will agree upon criteria which, if met, will eliminate the additional search for documents and will terminate the production, unless, of course, somebody finds a document or becomes aware of one that is somewhere in that stack of documents that has been eliminated. The party that is asked to produce documents has therefore satisfied their responsibility to provide a reliable set of documents in response to a document request, which hopefully also will be a good set of documents for the party themselves to utilize to prove their case or prove their defenses. And then after you do all that, then of course anybody, either in advance of production or subsequent to production, people can run search terms across the produced set of documents to try to get to specific issues. Before production, the parties can run privilege search terms. People can run terms for likely work product documents or materials prepared in participation in litigation, and do your normal privilege review and elimination. And then, of course, you always want to, if you're the producing party, if you're the party that has received a request for production and you're supposed to have to produce documents out of this large set of documents or large set of electronically stored information, you want to try to put a cap on your project and get a stipulation or some sort of closure with the opposing parties so that you can eventually show the court you've done everything you were supposed to do in order to produce documents for the matter. So those are the ways that I've seen it, things that we've done in recent history. And I think we saved, using both third-party document reviewers and their algorithms, I would say in a recent case last year, probably $50,000, $60,000 over what it would have cost for our attorneys to review emails, with probably less likelihood of actually getting to the actual important ones if our attorneys had tried to take the entire set and strategically run search terms or something to get to the relevant documents out of the huge stack, because there would have been so many irrelevant documents we would have seen that we would have had to deal with and somehow eliminate. So once again, I would be interested we've got a lot of experienced litigators on the line. I'd be interested in any input from anybody. And the way that those of you that have come in, the way that would be done is Molly would just turn on your microphone and you would participate. And if you need to raise your hand electronically so I can tell her to turn it on or she can see you, please do that. Well, I see Dan Weigel on, and he provided some material assistance to me. You got anything to comment on, Dan, regarding experiences you've had from a younger attorney's perspective? You're still on mute right now. Okay. I don't. All right, there you are. You're unmuted. Dan? Well, I guess we're just listening with great anticipation. He seems to be breathless. Maybe he's got a mic problem too. So
Henry, can you hear me?
We can hear you now, yes.
Oh, perfect. Sorry about that. Yeah, I've called it on my phone and I tried to merge it and it doesn't always work. But yeah, just to piggyback on a couple of your points, you know, particularly in complex litigation with a lot of parties that can, you know, you want to kind of, you know, use that, you know, thinking of the, you know, the specific case that I worked on with you, having, you know, addressing these issues with opposing counsel and your ESI vendor, if you have it at the outset, to try to, you know, determine the parameters, but also, you know, keep that dialogue going throughout, because as Henry mentioned, you know, we saved a lot of money for the client by using the tools that our vendor was able to provide for us. Now, that might not be the exact way to go in every circumstance, but just kind of knowing what's available and working with opposing counsel and your ESI vendor, especially when you're running into issues and needing to address on the fly. You know, that at least that's what I learned from my experience, if that makes sense.
Yes, and Dan is actually reminding me of something. Hal, I do see your hand. We're going to get to you in a second. We did have, maybe on that project, we were representing the owner, but we had the general contractor and 5 or 6 subcontractors, all who have sent separate requests for production with different requests. We were able to get the general contractor and all the subs to agree to the exact same procedure, so that we only had to do it once for all of them. And they each did reserve the right to ask for specific things if they found out that for whatever reason their specific subject matter was not fairly represented within the documents that were produced. But nobody ever came back and asked for anything else, so it worked really well. So Hal, what can you add? You're on mute. You have to unmute yourself.
Well, I didn't know I was being called on, Henry.
Your hand is up, and that's why you're being called on.
Well, that must have been an inadvertent, but Allison Ballard is helping me with this very same issue now in some securities litigation, or it's litigation arising out of the securities industry, where there is a massive amount to search, and we were able to get the other side to agree on search terms and use third-party vendors to narrow down production of documents, and it's helped us with identifying privileged documents. So it greatly shortened the process.
Yeah, when implemented correctly, it can be extremely effective. Thank you for your input. By the way, I just noted we were working on a case today. I won't say which one it was. I noted the report from our client that the ESI vendor charged $734,000 so far for that case. And one thing that's very valuable as far as getting rid of data from the standpoint of eliminating it and having everybody agree that it can be set aside and never has to be touched again is the storage costs associated with data can be extremely high. So if you can cut it down to a lot less, then you're going to pay for a lot less on a monthly basis for the ESI provider to store the information. You don't want to throw it away altogether. Obviously, it'll still be on the servers of the company, or it could be placed somewhere in cold storage. But you don't want to keep excess data on active storage at your ESI provider because they will charge you just to have dead data there. Any other hands up? Okay, well, I want to thank everybody for being present. Thanks for coming to Litigation Fundamentals with Henry Quillian. For those out there in the world, I need to state, because I think I failed to at the beginning, we are providing information that can be utilized by people in litigation. We encourage you and require you, in fact, to communicate with your own attorneys regarding all information that has been shared in this presentation. We are not providing you legal advice, and you need to rely solely on yourself or on your own professionals when dealing with these subject matters. But it's to give you ideas of what can be implemented to the best of your ability and also to the best of your benefit. So thank you very much. Y'all have a great month, and we'll see you next month.